All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All having business before the court are admonished to draw nigh and to give their attention to the court now sitting. Please be seated.
Good morning. We welcome you to the Kansas Supreme Court this morning. Look forward to arguments. I know everybody in the courtroom is probably familiar with this, but we may have people online. So I would like to explain that the court is familiar with the briefs and the record in the case, as well as the arguments that the parties or authorities that the parties have presented to us. We will at times be looking at our computers and notes to reference those things. So when we're doing that, it's not that we're not listening to the arguments, but rather that we are looking at those documents or making notes about the arguments for ourselves. We do that to assist us in understanding and processing the arguments. So that I will now ask Mr. Doug Shima, the clerk of the appellate courts, to please call the 9 o'clock docket.
Thank you, Your Honor. The first case on the 9 a.m. docket for Wednesday, May 17th, 2023 is appeal number 124972, State of Kansas versus Richard Allen Goens, Riley County, briefs both sides.
May it please the court, I'm Ryan Enninger, Assistant Appellate Defender, here on behalf of Mr. Richard Goens today. Present, ready for argument.
May it please the court, David Loudon, Deputy Riley County Attorney, appearing on behalf of the state of Kansas, present and ready for argument.
Second case is appeal number 123862, State of Kansas versus Thomas Kerrigan, Riley County, briefs both sides.
May it please the court, John Griffin, Assistant Riley County Attorney, appearing on behalf of the state. Be asking for 3 minutes for rebuttal, present and ready for argument.
May it please the court. Jeremiah Platt of Clark and Platt Chartered on behalf of Thomas Kerrigan, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. Thank you, counsel. I'll call forward the attorneys on 124972, State of Kansas versus Richard Allen Goens.
Morning, may it please the court. I'm Ryan Enninger, Assistant Appellate Defender. I'm here on behalf of Mr. Allen Goens this morning, defendant appellant in the present case. With the court's permission, I'd like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you, Your Honor. A Riley County jury convicted Mr. Goens of felony murder, attempted aggravated robbery, criminal discharge of a firearm, aggravated battery, aggravated assault, and possession of marijuana with intent to distribute. Trial court sentenced Mr. Goens to a hard 25 and also a consecutive term of an additional 142 months imprisonment. Unless I'm directed otherwise, I'd like to spend my time focusing on the first issue raised in our brief this morning. And I would submit the second remaining issue on the brief. Today, I'm asking the court to order a new trial on behalf of Mr. Goens due to the fact that the district court failed to instruct the jury consistent with the cautionary instruction regarding the testimony of accomplice witnesses. This is instruction from PIC 4th edition 5109. It instructs the jury to pay particular caution to the testimony of an accomplice witness, of which there were 3 in this particular case, I guess 3 accomplices, but there were only 2 that provided testimony at trial. The cautionary instruction was not requested below, so I must argue that this instructional error constituted clear error, requiring reversal of his trial.
other than the imprimatur of the court giving the jury, what else would tip the balance to get past clear error burden on this one? Focusing on the defense counsel's closing argument, where it was made clear that, this testimony was coming from accomplices, that they had deals. I can't see anything else that could have been said in closing arguments that, brought that matter in front of the jury any more clearly than what defense counsel did. So really, the only thing you got is, the judge reading from Pick instruction. So how does that doesn't even tip a balance? I mean, you've got more than to tip a balance. You've got to go further. So how do you get there?
I suppose my response to that, Justice Files, would be twofold. One is, of course, the attorney's arguments aren't evidence. So
Pick instruction.
right, and that Pick instruction specifically identifies and tells the jury beyond just my arguments, just beyond counsel's argument, that the counsel can argue about the evidence, but that specifically directs the jury to that evidence need to be viewed in this particular manner. And I understand that argument was made, and those were brought to the attention of the jury. But there's also been the other part of that is this court has consistently held that where there's a lack of corroboration and the extent and the importance of the accomplice testimony is acute here. And in this case, the state's entire pretty much case was built on the testimony of accomplice witnesses. So in those instances, I would argue that does become critical. It does become a situation of clear error if it's not provided to the jury, because in this case, we had a lack of corroboration. We had a lot of sort of differences everywhere in everybody's, especially in the details of the accomplice's testimony. For instance, one thing that I think I pointed out that I found should carry some significant weight here is both of these accomplices frequently discussed Mr. Goens and his firearm. One witness said, one accomplice said, well, he had a black and silver firearm. The other witness said it was camouflage. That's a very big difference. And in both cases, they said, I saw him with the weapon. Mr. Sutton, who drove Mr. Goens home from the incident, claimed to watch him disassemble his firearm and throw it out the window. At that point, you'd think he would have a pretty good view of what that was. Mr. Hitzman, Jalen, said that firearm was pointed directly right at him. He also, I think, should have had a pretty good idea of what that firearm looked like. And there's a distinct difference between those two testimonies. One's a camouflage, one's is black and silver. Other things, the witnesses.
I'm sorry to interrupt
No,
you. Was a general credibility instruction given?
it was.
Okay, so you're pinning this on that there wasn't an instruction about credibility of accomplice testimony, but a general witness credibility. Okay.
Right, a general witness credibility instruction was provided to the jury.
And why didn't that suffice?
Well, I think it didn't suffice because in this case, we have so many different differences between the accomplice's testimony.
Right, but they're all witnesses.
Right, I'm sorry, I don't understand. They're all witnesses, but
So the jury was instructed, if, a witness, it's up to you to decide the credibility of witnesses. And so even though they're accomplices, they're still witnesses, right?
correct.
So I don't understand why that didn't.
Well, I mean, basically what I'm arguing is based on this court's precedent, what I've seen is, and what's out there is if there's a number of issues and lack of corroboration between the accomplice witnesses, this court has consistently said that that instruction should then be provided.
Right, so it should then be provided, or that it's legally appropriate and it's factually appropriate. And then as Justice Biles said, we get to whether or not a different outcome
Right.
would occur. And given that they were instructed on the credibility of witnesses, what's so you're saying that including the word accomplice in there would have made a difference in the outcome of trial, right?
That's, yeah, under the clear air standard, I have to argue that if that instruction had been provided, the outcome would have likely been different in this case. And that argument is that due to the number of sort of differences in everyone's testimony, that should have been even brought forward even more for the jury to appreciate that counsel's arguments, the general credibility and being told is not enough because it has to be specific. The instruction's there for a reason. It should be provided to alert the jury to that fact.
Along those lines, one of our cases, the Moore case, when talking about this issue, described it this way. Or described the question we should ask this way. And that is it possible that any of these jurors who heard this testimony didn't realize that these witnesses' credibility as accomplices was at stake? From your perspective, do you think any of these jurors did not realize that these witnesses' credibility was at stake?
No, I think they absolutely would have recognized that their
Right.
credibility is at stake, but that instruction then says, make sure you weigh.
I understand that,
heavily.
but our precedent says that that's one of the ways that we can answer this question.
Correct, and I agree with that. But I as I said, in a case where you have all these different accounts from different witnesses.
But
the
you
court has
concede
also
at
said
least that it sounds to me like you're conceding that the jurors in this case were well aware that the credibility of these accomplice witnesses was being contested by the defendant.
Well, yeah, I mean, absolutely. I mean, that was, through the entire trial, defense counsel brought those issues out. I'm just saying that in this particular case, under the facts of this case, due to the fact that the entire state's case was built on accomplice testimony, this instruction should have been provided, and it was clear error not to do so.
You mentioned the discrepancy in the testimony, but wasn't the defense essentially that whether or not there was a plan? I mean, isn't that what it really boils down to? And then how do you account then for the mother of one of the accomplices' testimony that sort of corroborates the existence of a plan? She's not an accomplice.
Right, and I understand what you're saying, just that seems to be an independent corroboration beyond just the accomplices themselves.
Right.
So somebody that's not an accomplice, but is also a witness and has been corroborating. The thing I'd point you out to in the record would be her testimony. I think it's around 396 to 398, where she says, when she initially explains what her son told to her, there's important detail in there that she says he told him that he drove there, which is completely different. And so there's another discrepancy there, even in what she's saying. And so I think that's important too. There's a number, and I understand there's a difference between discrepancy on the details and discrepancy on a sort of general corroboration. And what I'm arguing today is that the details matter. That we can get to a general corroboration, but when you really get down to it, a lot of these details are big problems, such as the color of the gun.
And I guess I was wondering also whether the cautionary advisement that we have for accomplices should be extended to non-accomplice witnesses who are just talking about the admissions of an accomplice.
And that's something
I don't know that we've addressed that, or
Right.
if how you would view that sort of argument.
I think that supports my argument as far as all the evidence in this case came in one manner or another through an accomplice. Now,
Well, didn't Goens admit to bringing the gun, for example?
he admitted to bringing a gun, and he admitted to the.
So why does the color
marijuana.
of the gun matter? I mean,
Because
why
it's a discrepancy.
why would the discrepancy of the color create a real possibility that the jury would have returned a different verdict when Goens has already admitted that he brought the gun?
I just think it's an important discrepancy in the fact everybody's recollection of this event and the fact that, yes, I had a weapon,
But
but
the discrepancy has to lead us to be firmly convinced that had the instruction been given, it creates a real possibility the jury would return a different verdict. And you've focused on this color discrepancy. And I guess I'm just asking, how does that, why would that matter? In a juror's mind, even if they were inclined, perhaps.
Well, I think it matters because there's some indication here, as Mr. Goens testified, that, hey, I actually gave them money to buy this marijuana. I became concerned that I was actually the one that I was going to get ripped off. So I then approached to say, hey, what's going on here? So I think it's important that if these two accomplices have a credible accusation against my client, then they ought to remember some details about like the nature of the weapon is my argument on that those details would then matter. And if they just sort of ad hoc came up with these things, then their ideas, their testimony regarding the details would likely be different. It's easier for us to come up with a general sort of corroboration of this was our plan, but then things start to fall apart. As I know this court's seen through various investigations, interrogations of defendants during, things start to fall apart when you start to get to the details. See, I'm out of time. If the court, unless the court has additional questions. Thank you.
May it please the court, David Loudon, Deputy Riley County Attorney, appearing on behalf of the state of Kansas. Like Mr. Ettinger, I will submit the second issue on the brief, unless this court has any questions. As with regard to the first issue, it should be clear that the defendant did admit to having the gun, bringing the gun, firing the gun, whether he did that on purpose or intentionally. That remained, that's something that was an issue, but it was a felony murder case. So there was a death in the context of an attempted robbery or a robbery. What we had, the central issue in the case was he there to buy marijuana or was he there to rob Mr. Zomaznik? They would submit that basically what's happening here on this, in this appeal, the argument is the jury should have paid attention to this other stuff and should have come out with a different result. So we're going to complain that this accomplice witness instruction would have been the turning point for this jury. The state would submit that that is patently wrong. This court must be firmly convinced that had this instruction been given, that the outcome of this trial would have been different.
Did the other witnesses make any deals with this?
Only the two co-defendants who testified, Shamar Sutton and Jalen Hitzman.
Was that explored on cross-examination?
Yes, that was explored on cross-examination. They discussed, in fact, that they got reduced sentences and reduced charges in exchange for their testimony. It was a central part of the argument. As Justice Stiegel has pointed out, I mean, some of this stuff had come out. How does this change things? I don't know that it changes anything. This court has indicated that an accomplice instruction is not a mandatory thing. It does not have to be given. This court has indicated some cases that there is no error, let alone clear error, when the general credibility instruction is given on testimonial evidence. I would submit that there has been no error here, let alone clear error. This court can't ignore that in the past, it has said juries can be trusted to figure out that when testimony and the credibility of that testimony is an issue. Jurors are not stupid. They can figure this stuff out. We would submit that everything that happened in this case gave them the roadmap to make a decision that was in line with Kansas law. I don't understand why we even have an accomplice instruction. Given this general credibility instruction, it's unduly focusing on one part of the case, I believe, and we try to shy away from doing that. Nonetheless, I'm not here to overturn history when we have, case law saying that this is somehow important. But I think the recognition that this court has had regarding the general credibility instruction and that it's not a necessity somewhat undermines the notion that it's this all important thing that the defense wants to bring forward today. I will say If we are going to look into some of those things that the court has in the past said, let's look at how important was this testimony, this accomplice or co-defendant testimony? How important was it in the case? It was very important. We'll concede that. We disagree with the defense. There was corroborating evidence. Dawn Hitzman, Jalen and Dylan Hitzman's mother.
And I'm going to interrupt you there. Just for clarification, did the accomplice testimony go only to the contested question of whether there was a plan to rob? Or did it also go to the elements of criminal discharge?
I think the focus was on,
The focus was on plan to rob, as far as I can tell.
and the felony murder. That certainly was the
Well,
central
but
issue. of
wasn't the
case.
felony murder predicated on criminal discharge as well? Or am I reading that wrong?
I think it was based on the
The ag robbery
the
only?
robbery. Yeah, I could be wrong and I don't want to misstate the record, but that's my memory of it. So what we have is a situation where Courtney Yao, who is not a co-defendant, accomplice, she was an innocent person in that car. Well, when I say innocent, maybe she was part of the drug deal, but she was in that car and she said, look, they came to the car, Dylan and Jalen came into the car. They were acting cagey and just very suspicious. They never showed any money. They wanted to see the drugs before they gave any money, so they never saw any money. And then the defendant comes up and he's knocking on the window and he has brandished his firearm. And in the course of that, he demands the drugs. His testimony is, I went up there and I thought, what's going on here? And so I do brandish my gun. And I do say, where's the money or where's the drugs? I don't want to get ripped off. He never asked for his money. Curious. There is corroboration, the fact that he did the robbery. So this isn't something that's standing alone on an island with a co-defendant accomplice testimony. Courtney Yao, who was injured in this case, and she was a victim of an aggravated battery. He was there to corroborate, along with Dawn Hitzman's testimony, and one could argue, okay, she's only parroting what Jalen Hitzman has told her.
Can I follow up on my earlier question? Because I just looked at the jury instructions and it appears to me that in jury instruction 4, which is the felony murder instruction, that the predicate or the underlying felonies are listed as aggravated robbery and or criminal discharge of a firearm. And the jury came back with a guilty verdict on both.
My apologies, Judge.
And so if that's true, does any of this discussion about the accomplice testimony really matter? What I'm driving at is, let's say hypothetically, we were firmly convinced that had this instruction been given, the jury might have disbelieved the accomplice testimony on the robbery. Does that I guess my question is, would that have changed the outcome when we have a guilty verdict on the criminal discharge?
I don't think so, no.
Does that question make sense? Are you tracking?
Yes, I am. I think so, yes. Because if the whole focus is on whether he was there to rob or not rob, still doesn't take away from the fact there's a criminal discharge in the case, is what I'm taking you to mean.
Yeah, I wanted you to comment on whether you thought that was made sense or not.
It does make sense, yes.
But does that create an alternate means issue, the way that the jury was instructed? In other words, does the listing of multiple felonies create alternative means of committing felony murder?
I think that's an option within a means.
Well, was there a guilty verdict on it? He was charged independently with criminal discharge.
He was, and he was found guilty of that.
Okay.
Yes.
He was charged separately.
He was
criminal
charged
discharge.
separately, yes. So with that, the state would ask, based on the briefs and the arguments today, that this court uphold the conviction, deny relief on issue number 1, and I will submit issue number 2 on the brief and ask that this court affirm the sentence given in this case. Thank you.
May it please the court.
Can I jump in and ask you to address that subject we were just discussing? Do you think the accomplice testimony was relevant to the criminal discharge guilty verdict?
I was concerned that I'd have to say yes. I think in this situation meant that jury could have believed that the accomplice testimony was unreliable and untrue, incredible.
How does that
So-
undermine the evidence of criminal discharge?
Well, I
Let's
think,
just say that you're right, that
Well,
the
I think-
jury would have disbelieved the accomplice testimony. Can you
Well, then
be
I think-
specific as to how that undermines the criminal discharge?
then I think we might end up with a completely different jury verdict would be the only way.
But I'm just asking you to articulate how their testimony, how the accomplice testimony supported. In other words, again, if the jury had disbelieved the accomplices because they were given this instruction and they thought to themselves, it's obvious they're lying because they got deals. How would that have impacted the evidence about the criminal discharge?
I guess my response would be that there would have to be the jury would then maybe have to acquit on criminal discharge based on the test, not accepting the testimony of the accomplices. But that's the only response.
So are you saying that somebody shot at the vehicle, but not the defendant?
That would be the only possible outcome. Or it's a situation, I know the facts were as they were driving away. My client there was a lot of testimony that they were all falling out of the vehicle. Okay. Jalen said that he was tumbling out of the vehicle with Mr. Goens, and that's when the gunshot went off. So there's some evidence there, I think, that the jury could rely on, Your Honor, to say that my client wasn't actually responsible for the discharge of the weapon, if you understand what I'm saying. If you look at the record, Jalen said, he opened the door. There's a big difference actually in what everybody says about what happened in that car. I know the state brought up Courtney's testimony, and Courtney's testimony was that as soon as my client appeared, brandished his weapon, Jalen and Dylan hopped out of the vehicle. And Jalen says, and then she goes on to say, my client chambered around, she could hear him chamber around, pointed the weapon at the Tanner's back behind the seat. At that point, she said he demanded the marijuana, and that was Courtney's version of events. Jalen said that he came up, brandished the weapon, pointed at him. He told Tanner, go, drive away. As Tanner pulled away, he claimed that he was jumping out of the vehicle, tumbled to the ground sort of with my client and with Mr. Goins. And I would have to argue that that would be the window in which the jury could say, well, at that point, perhaps Jalen was actually the one that caused the firearm to discharge.
I thought Goins admitted to firing the gun.
I don't think he admitted to firing it. I don't want to misstate the record. I'd have to check that again, Your Honor, but I think he admitted to bringing it, but I don't think he may have said that as he fell to the ground with Jalen, is sort of my recollection that the firearm went off.
Yeah, he said it was an accident, but
Exactly.
he didn't try to say someone else.
Well, I think there's some implication there that it was potentially caused by Jalen tumbling on top of him. So I think there is some room there for the jury to acquit on that. For additional questions for me, I yield the remainder of my time. Thank you, Your Honor.
Thank you. Thank you to both counsel in this matter. The court will take this matter under advisement, which means that the court will later today begin discussing this, the resolution. Case will be assigned to a justice for writing, and court will then continue working as a group to reach a final decision, which will then be filed, published on the kscourts.web or website, and there will be a press release announcing that it'll to the public so that they can read the decision. Thank you, counsel. That call 123-862, State of Kansas versus Thomas Kerrigan.
May it please the court, John Griffin, Assistant Riley County Attorney on behalf of the state. Requesting 3 minutes for rebuttal.
3 minutes is granted. Thank you.
This case stems back from March 1st of 2020, when Trooper Walker from the Kansas Highway Patrol initiated a traffic stop on Mr. Kerrigan late at night in Manhattan, Kansas. When he made that traffic stop, he approached the vehicle and observed some signs of impairment, which ultimately led to a DUI investigation. During that DUI investigation, the defendant had requested an attorney at least twice before the breath test was administered. He was also read his Miranda warnings prior to the breath test. This case was at the district court level. The defense filed a motion to suppress. The court found in that motion to suppress that the breath test results should be suppressed in light of Dumler v. Kansas Department of Revenue. The state filed a motion to reconsider after realizing the statute in question, which was 8-1001, had actually been updated since that Dumler decision came out. And the court reversed this decision, stating that that evidence is no longer suppressed. We moved on to a bench trial where Mr. Kerrigan was convicted of DUI. That decision was appealed. The majority of the Court of Appeals found that in the new statute 8-100C1, that the timing element was ambiguous and ineffectual because it wasn't worded strongly enough, therefore it was flawed. But if you go back and look at the timeline of this in 2009, KSA 8-1001 K10 was in place when the 2015 Dumler decision was ruled on by this court. And then in 2018, the legislature actually changed that provision and made a timing element for when a defendant could request an attorney according to their statutory rights, not their Miranda rights. And this is clear because the legislature intended to change that statute due to the Dumler decision. The Dumler decision.
What evidence do you have to support that statement? We would of course have to find the statute ambiguous before we went to legislative intent on the plain language. But when you make that statement, was there anything in the legislative history to talk about that?
I didn't find anything specifically in the legislative history, but if you go back to the presumption, and the presumption applies that when the legislature does change the law, that it intends to not only change the prior law, but any court decisions relying on that law. And that's what we cited in our brief, the Jarvis versus Kansas Department of Revenue, when they stated when the legislature does revise an existing law, the court presumes that they intended to change it as it existed before.
Where does it say in the amended statute that the language to request an attorney should not be honored? I just don't see that. And I think that's where the Court of Appeals majority kind of hung their hat, is there's really no difference between the two statutes when it pertains to that question.
They did take some language out of the previous statute. So in the new statute, it says after the completion of testing, the person may request and has the right to consult with an attorney. In the previous one, it says after completion of the testing, the person has the right to consult with an attorney and may secure additional testing. To me, and what the state's arguing is they In Dumbler, they stated there's no bright line rule on when the defendant had to request for an attorney. So if he requests for an attorney before the test, the officer still had to make that request known, and let him contact his attorney. The change that the state is arguing that because of that decision, the legislature put that timing element in it. And it doesn't mean that if he requests an attorney before.
I guess I don't see, at least explicitly, any timing element in the new statute. Other than your kind of inference that they changed it, but I don't see even how if they modified it in some way, how that affects the question here.
I think it does modify it to make it more clear when the defendant has read their advisories that they are not allowed an attorney prior to testing. But if they want one, they may request one after testing in order to secure additional testing. Now, I don't want to confuse this with the Miranda waiver where that's a custodial interrogation, because that's something completely different in this.
Doesn't the statute say after testing, the person may request?
That's exactly what it says, yes. So that
It seems to me to have a timing element to it. Would you?
excuse me?
That creates I mean, when you use the word after, that's a temporal adjective. I mean, it's describing a period of time, right?
Yes. So yeah, so building on that, yes, that's what we're arguing is that timing element was put in there, that after the testing, they may request.
Was that in the prior statute? The word after testing?
It says after the completion of testing, yes.
It was in the prior statute too.
Yes.
And I think maybe that's what Justice Rosen's asking about. Are we really just questioning the Dumbler decision then?
That would be our main argument, that Dumbler is no longer good law, stating that.
Well, but if that key language hasn't changed, why isn't Dumbler good law? There's another reason Dumbler might not be good law, which is that it got the statute wrong the first time around.
That could be.
But didn't the prior version of the statute had a temporal element referencing the right to consult? But in the prior version of the statute, there was that temporal after didn't modify the invocation, the request. Am I reading that right? Under the old statute, the temporal elements are largely the same, but what that phrase modifies has changed. Previously, that modified only consult, the actual consulting with an attorney, but the new version retains consulting with attorney, but also adds the request.
Yes, and that's correct. That's what they did add, and that's the reason why there's a timing element with the new statute as opposed to the old statute, is that they may request an attorney after the testing and instead of before.
Is that, if that's true, I'm hoping you are too, be able to look at before and after right next to each other. Does that mean, because of the way the commas are, that you only have the right to consult with an attorney if you make the request? So it says, and the person may request and has the right to consult with an attorney. You're saying that that's not an independent right to, we know the statute no longer gives the person a right to consult with an attorney.
I think even before the statute did not give the person the right to consult with an attorney about whether or not to take the test before the breath test was given. I don't think that has changed.
No, that's a separate thing. There is no constitutional right to consult with an attorney. That's the very first line, and then it's separate under K3 in the second statute. But this is say, if we agree with what you're saying, then you don't have the right to consult with an attorney after completion of the test.
I think you do, a defendant would have the right to consult an attorney after the test. They just have to make that clear to the officer that that's what they want to do and that they want to do it for purposes of getting additional testing.
Okay, so let's do a hypothetical. I'm pulled over and there's enough evidence there to have me take a preliminary breath test, a PBT. And that gives enough evidence for an evidentiary test. Oxalizer 9000 or whatever it is. And I say before that, you give me my advisories. You're the law enforcement officer in this hypothetical. You give me the advisories and I say, okay, I understand that I don't have the right to consult my attorney on whether to take this, but I want an attorney when this is over. When the test is done, I want an attorney. Under your reading of the statute, that I would have to say that again.
Under the new statute, that would be our argument that after you take the test, that you would have to make that right asserted again. Now, that's not to say the officer and me in this hypothetical can, after the test, say, hey, do you still want to?
But we're not, that's not what we're talking about here. What we're talking about is that even though there would be undisputed evidence that I say, okay, I understand that I can't call my attorney right now, but right after this test is over, I want to call my attorney because I want a separate test. And you're saying that wouldn't, based on the new statute, I would have to say that again.
I think it depends on how you say it. In this context, when you said after the test, I want to consult with my attorney. I don't know if that would carry over from this statute. Well, that is a post-test request because, so when you said the words, after this test, I want to consult with my attorney.
But based on your reading with the, as Justice Wall said, the temporal element modifies the may request. I don't understand how you could say that under this statute that would count as a post-test request.
I think they would have to, after the test, request it. If the officer doesn't come back and say, hey, do you still want to
That's what I'm
take the
saying.
test? I think in order for
And I'm
the
saying, even
statute-
though I just said that 3 minutes ago, so now there's under this new statute, I have to say it again.
I would think so, and I would argue that because of that statute that put that timing element in it, that the officer read to him, so after testing, you may request and you can consult with your attorney.
Well, even though it seems nonsensical under the hypothetical just given to you, still applies because that's simply the rule. Is that your position?
It is our position that that is the rule. They read their advisories that if they do want an attorney, that they have to make that request after they take the breath test.
You're saying that because of those 4 words that are added, that's a complete, turnaround from Dumbler.
Yes, and I say that because of the way the legislature did change that. It was,
So the legislature intended my hypothetical.
yes. I see my time is up.
Questions? Thank you.
May it please the court, Jeremiah Platt of Clark and Platt Chartered on behalf of Thomas Kerrigan. The state's position in this argument requires this court to read words into this statute, KSA 8-1001 that just aren't there. After the completion of testing, the person may request does not equal that a person may not request to consult with an attorney prior to testing. And I don't know how a law enforcement agent would ever keep someone from making that request. A person just says, I want to talk to my lawyer, then that the words have already been spoken. And I don't know how a law enforcement agent would keep them from doing so prior to the intoxilizer test. The statute prohibits an individual from consulting with an attorney regarding whether to submit to a breath test. Nothing more.
Right, can I ask you, I understand that argument, the may, takes away from that temporal element.
Yes.
But then what meaning does the 2018 amendment have then? I mean, essentially that interpretation renders it the same as the 2009 version. It appears to me, but
Yeah.
maybe I'm missing something.
Honestly, I think that the 2018 amendment, it was in a broader amendment of all the DUI statutes. And I think it was mainly made to make this statute more concise and to explain what the law is to individuals who are being asked to take a breath test. But I don't think that the wording and the way that they changed the specific wording of that statute really was meant to change that a person cannot make a request before they take the breath test.
But the word,
Non-substantive.
That would be our.
Cleaner.
Yes, it wasn't clean. I think it was just something to make it more concise.
the word must doesn't make any sense. They don't have to ask for an attorney.
They don't have to, but the statute also doesn't say that the request must come after they take the breath test.
How else would they word it then if it has to come after the test?
Well, I think,
And permission, but not forcing them to ask.
correct. And I think in our brief, we outlined a couple of different ways that the legislature could have written this, that something along the lines of no request for an attorney will be honored unless that request is made after submission to the breath test. Or any of the other ways that we explained in our brief.
Can I just ask some very pragmatic questions to help me understand what actually happened here in terms of, I mean, your client got an attorney at some point.
At some point, yes.
And so when was that point?
Well, it was at least a day or two after he was released from the jail.
So what would have, in your view, what should have happened? I mean, how would it have played out in practical reality had this request been honored?
Well, the facts in this case were that the trooper already had seized Mr. Kerrigan's cell phone. So he had no opportunity to use his cell phone. He wasn't given an opportunity to use a phone there at the station.
So what should have happened is, from your perspective, is that the arrest happens, the request is made, the tests are administered, and then the state gives your client the opportunity to call the lawyer.
And I think that's the law that's been explained by this court and by the Court of Appeals over and over.
So the only difference between that and what actually happened is the 24 hours or so between, or whatever the period of time was.
Correct.
Well, what doesn't the statute contemplate in practical terms, as Justice Stiegel says, that I'm going to call my attorney and I'm going to get an independent test. I'm going to get a blood test at the hospital so that I have evidence at the time to refute. And also consulting attorney, maybe it didn't happen in this case, but an attorney would say, don't talk to anybody.
Correct.
Don't talk to the police officers. Don't talk to anybody.
And the Demler decision outlined that it really doesn't matter why the individual wants to talk to an attorney. They have the right to talk to an attorney. And that may be because they want to ask the attorney, should I ask for additional testing?
Well, we're talking exclusively about the statutory right. Correct. Is that correct?
Correct. Yes. Yeah. Everyone has the constitutional right to speak with an attorney when they're in that position, when they're in custody and they're being questioned. But we're talking about the statutory right as well, where they're told you have no, there are two parts of this statute that are crystal clear. One, that there is no right to consult with an attorney about whether to submit to the test. And two, that a person has a right to consult with an attorney once they have submitted to that.
So with
test.
respect to that first point, no right to consult on the test. Why is exclusion of the test results the appropriate remedy for a violation of this statutory right? Let's assume that we agree with you that there was a violation of the statutory right. Why is excluding the test results the proper remedy?
Well, history for one.
Well, I know that
Um,
that's what we've said.
right,
But
right.
I have a little disconnect on that.
Sure.
Because the test result, I mean, having the attorney wouldn't have stopped the test.
It
So
wouldn't have
why
sto-
exclude the results? I can understand there might be other remedies available.
Sure. And I think that one of the reasons is that one of the reasons the individual may want to speak to an attorney is to ask. They have also told me that I have the right to additional testing. Should I do that? And the attorney may tell them, yes, you should ask for additional testing so that you can go get your own independent blood test done. And if that blood test shows something different than the breath test, there's a disconnect there in what the actual results.
So I think what you're saying is that the loss of the opportunity for follow-up tests can only be remedied by the exclusion of the results of the first test.
Well, I don't want to say only, but I think that is one of the reasons that exclusion of the breath test is the proper remedy.
And practically speaking, what is the temporal element? I mean, when do you lose? I mean, when does the additional testing become not beneficial from a scientific perspective in terms like so much time has passed
Sure.
that, you're not going to get a reliable result about whether there was impairment while operating the vehicle?
Well, I think that one, every person's body is different and it's going to process alcohol differently. So it's hard to say for each specific person when that time is. But if we look at the elements of a DUI, a 0.08 or more within 3 hours of operation is one way to charge driving under the influence of alcohol. So it would be best if this person could get this additional testing done within 3 hours of operation of that vehicle.
How does that work practically? Like, does the statute contemplate that the law enforcement is required, for example, to transport him to a hospital or to?
The case law contemplates that they are to give them a reasonable opportunity to have an independent test completed.
What does that mean?
I think that it means that an officer should place the person in a vehicle, transport them to a hospital,
Because
and at least allow that person to go in and ask, I need an independent blood draw.
so very practically, I mean, we're talking about something that has to happen in minutes, right?
Not necessarily.
We're in a 3-hour window from operation.
Yes, and I practice a lot of DUI law and I try a lot of DUI cases. Oftentimes a person gets pulled over, the field sobriety tests occur, and they're down at the station within an hour. And they're taking a breath test 20 minutes later due to a 20-minute observation period. And so you're talking about an hour and 20 minutes. And if that person then turns around and says, I'd like to talk to a lawyer and I'd like to have independent testing done, where I live in Manhattan, it's about a 5 to 7 minute ride from the jail to the hospital. Hour and a half is a good time frame. And they
Will
can get
you
there.
refresh my memory? Was your briefing and your challenge based on not just on the statutory right, but also the constitutional right to counsel or not?
It was more geared towards the statutory right.
So I'm asking whether you raised the constitutional issue.
I believe that we did not. So, and I will just say that one of the confusing things that occurred in this case was that Mr. Kerrigan was also read his Miranda rights before he took this breath test. So he was advised both, you do have the right to talk with a lawyer and you don't have the right to talk to a lawyer about whether to submit to testing.
Right, and I wanted to ask about that because, it's very confusing because we had conflicting testimony and we didn't have body cam or anything. But it seems like when I went through, the district court did make a finding that there was a request after the PBT. Okay, so
Yes,
made a credibility finding or whatever. And that would have been, he was read his Miranda rights right after the PBT. So he did invoke his right to counsel after getting his Miranda rights, correct?
I still have some question about that because there wasn't a video, so the timing of everything. I mean, I know he was.
I want to
read
know
his-
what the district court found.
I think the district court found that the request came after Miranda and either just with the reading of the implied or the testing notices, or just briefly,
Right.
right after that.
But there is
And-
no constitutional claim based on that.
Well, I think that the question is, what statutorily he has a right to,
To mount a defense
yes,
and get,
and to talk to an attorney after he takes this test. And the wording of the statute, I mean, we're talking about the Court of Appeals majority and the dissent both spent a lot of time discussing the ambiguity of the statute. And the mere fact that we've got 3 Court of Appeals judges that disagree about the statute's interpretation should show you that it is ambiguous. We're talking about 3 people with over 100 years of combined
well, the
experience in the
dissent
legal
said
field.
that there is no ambiguity.
Correct. But the majority said there is ambiguity. And so, I mean, to me, that shows there is ambiguity. When I keep going back to the question about what the state is attempting to do here with its position, it just seems to me that the state is trying to keep people from exercising not only their constitutional but statutory right to consult with an attorney once they have submitted to a breath test. Your decision here will have far-reaching effects. I mean, law enforcement agents throughout this state are waiting to see about the results of this case to determine, can we simply ignore a request for an attorney after a breath test is done if this person doesn't raise it again?
Why would
Ask
they
you-
do, sorry.
Mine's a quick one. Are you asking us to affirm the Court of Appeals finding that the statute is ambiguous, or are you asking us to find that the plain language of the statute as read in Demler?
Well, I think I think the court has to make that determination of what, is it ambiguous? I
Well,
mean,
right, but what do you think?
I think that the question about this specific portion of that statute is ambiguous, may request. It doesn't say they may not request beforehand. It doesn't say that only requests made after.
That's a
submitting
plain
to the
language
test.
argument.
True. So I suppose it's a little bit of both. Going back to Justice Standridge's example, I mean, there's a number of examples that could actually occur in the field. I mean, a person who gets pulled over and immediately says, I want to talk to my lawyer. Or you could have an example like Mr. Kerrigan, who throughout his, time with the officer, with the trooper, made that request at least 2 times, we think 3 times.
So with those facts, my question is, and I might be missing something totally obvious, but why isn't this a constitutional claim?
Well,
Why are you arguing the statute?
well, I think that that's the way it was framed
But why?
in our motion.
Is there
to
some
suppress.
reason?
I think it's a stronger argument from the standpoint of what actually occurred in this case. What actually occurred is Mr. Kerrigan made a request for an attorney. He then submitted to a breath test, and then the trooper just ignored that request because he believed that he didn't need to honor it because of the statute. And because Mr. Kerrigan didn't
Doesn't the
reinitiate
Miranda,
that.
I mean, he was Mirandized and it told he has a right to an attorney.
Correct.
I had another question. All right, I'll think of it in a minute. Oh, you're out of time.
I'm out of time, so I apologize. Thank you.
You reserve 3 minutes.
I think in this case, I don't think the trooper ignored the request for counsel. I think it was testified to as in the record that if he would in fact asked him for an attorney when they were riding to the police station, he would have let him talk to him.
That reminded me of the question. Why, because we do have these factual disputes, because there are, the defendant says that he did ask for an attorney after the evidentiary test. And Walker said, well, I don't have any recollection, but if he had, I would have allowed him to. Okay. And then the district court never made a factual finding about who was telling the truth or who, a finding of fact. Should we just remand it back down? Because then we don't even have to deal with the statute, because if the district court finds that he made the request, he never resolved that credibility. It never resolved it.
I think that remanding it down to the district court would be one option that this court could do to have those specific fact findings. Does the state wish that there was some audio or video of this incident? Sure. I mean, we may not even be here if there was. But what do we do before there was any body cam Brady videos, dash cam videos, or anything? All we had to go on was physical evidence and testimony. I think the court probably should have made that finding. I think, I don't know, I mean, I can't speak for the judge why she didn't make that finding.
Okay, thank you.
Can I ask you about just what your view of the law enforcement's obligations are under the law? And in a hypothetical case, let's say it's clear that the officer in my hypothetical example actually does just completely ignore a request. And there's no dispute that the request was made prior to the administration of the test, but then it just gets totally ignored. In your view, does the law enforcement have the right to do that? Or framed another way, do they have an obligation to provide an opportunity to contact a lawyer under the Constitution?
Under the Constitution, we're talking about the difference between the statutory right and the Miranda right. I think it depends on what the defendant does and says.
Well, let's just say the defendant is getting arrested and says, I want to talk to a lawyer. I want to talk to a lawyer.
I think he absolutely does have that right to call and contact a lawyer as soon as possible.
And it may be after the test is administered. Is that right?
Yes, could be.
But it's that, I mean, I guess I don't understand why you're here arguing we don't have to let him talk to his lawyer.
I don't think my argument is we don't have to let him talk to his lawyer. I think that if he does request that lawyer before a test, the officer still does have that discretion to allow him to do it after the test. He doesn't have to
But I
wait.
understood you to say that the officer can just utterly ignore the request because it didn't happen after the test was given. The officer only has to let him talk to the lawyer if the individual renews the request after the test.
I don't think he has to ignore the request. I just think with this statutory change, if, say, for instance, he forgets that he asked for his lawyer before the test, then he's not obligated.
Well, I might completely agree with your argument about the statute. And I understand that it's framed entirely in the context of the statutory right. But I guess I'll just reiterate my confusion to some degree as to why, if there really is a constitutional right, that trump the discussion of the statute.
I think in order to consult with his attorney, yes, I think he absolutely does have that right. But I think there's some lines blurred between why does he want to contact his attorney? Is it to say, hey, do I need to answer questions, if whether it's a custodial interrogation
Why should
or.
the state care about that? That's not any of the state's business, is it?
It's not, no. But if he's requesting his attorney under Miranda constitutional attorneys, I don't think there's that timing element involved like there is with the statutory. Right, if that makes sense.
Yes, okay.
I see my time is out. State's asking this court to reverse the Court of Appeals and affirm the district court's ruling that Mr. Kerrigan's statutory right to counsel was not violated. Thank you.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. The court is in recess until 10:30.
Bye.